This is Bloomberg Law with June Grasso from Bloomberg Radio.
Every day from now until the election, we're giving out $1 million prize. And all you have to do is sign a petition in support of the Constitution. It's very straightforward. You don't even have to vote. You don't have to vote. You just have to sign a petition saying you believe in the Constitution, which if you already believe in the Constitution, you're just signing something you already believe, and you can win $1 million. That's awesome.
Awesome, maybe. Straightforward, not really. Elon Musk left out that being registered to vote is a prerequisite to being eligible for that $1 million check. The world's richest man has already committed at least $70 million to help former President Donald Trump win the presidential election. Now Musk is pledging to give away $1 million a day to voters for signing his Political Action Committee's petition supporting the First and Second Amendments. Registered voters in swing states, that is. He's already given out 2 of those $1 million checks in Pennsylvania and has plans to expand the sweepstakes to registered voters in 7 battleground states this week. Pennsylvania Governor Josh Shapiro, a Democrat who previously served as the swing state's attorney general, said Sunday on NBC's Meet the Press that law enforcement should look into Musk's giveaway.
I think there are real questions with how he is spending money in this race, how the dark money is flowing, not just into Pennsylvania, but apparently now into the pockets of Pennsylvanians. That is deeply concerning. Look, Musk obviously has a right to be able to express his views. He's made it very, very clear that he supports Donald Trump. I don't, obviously we have a difference of opinion. I don't deny him that right. But when you start flowing this kind of money into politics, I think it raises serious questions that folks may want to take a look at.
Does Musk's giveaway violate the law or not? Well, it depends. Joining me is elections law expert Richard Briffault, a professor at Columbia Law School. Rich, tell us about Trump's giveaway.
So Elon Musk is offering to pay people to get other people who are registered to vote to sign a petition supporting free speech and the right to bear arms. So if you're able to get somebody to do that, you will get $47 for referring a registered voter to sign the petition. In addition, he's going to put the names in a lottery, and one person a day will then get $1 million if they're a registered voter who signed the petition. So that's the goal, is one petition signer, and in order to sign the petition, you've got to be a registered voter, will get $1 million in Pennsylvania, and then also he's doing the same thing in other states.
And it's just the swing states.
Just the swing states.
Pennsylvania Governor Josh Shapiro said, I think it's something that law enforcement could take a look at. Does this violate, first of all, federal law?
Well, there is a federal law that prohibits someone from paying someone else to register to vote. Not just to vote, but to register to vote. The trick here is it's not clear whether Musk is paying only new registrants, or whether if you registered to vote 20 years ago, you still are eligible, you still get the money. If you're bringing in people who registered 20 years ago, or you registered 20 years ago, you're still eligible for the money. And it's not clear if the federal law, which prohibits people from registering to vote, also applies to paying people who registered a long time ago as opposed to in response to the payment. I think the federal law was probably intended to prohibit paying somebody in order to get them to register to vote. But it's not that clear. It just says pays or offers to pay or accepts payment for registration to vote.
Or for voting.
But voting isn't coming up in this at all. He's not paying anybody for voting. He's entirely focused on registration. And when it says pays or offers to pay or accepts payment for registration, it's not clear whether that means new registration. You weren't registered before, you got paid, and now you're going to register. Or if it turns out he's paying everybody in the state who registered, even if they registered in 1980, because they registered. Although his intention is clear to get new people to register, and doing that would clearly violate the law. He's written it in such a way that it would seem to apply to people who are already registered, who registered before this, and therefore are not being incentivized by this to register. It's not clear if the law applies to them. And the way it's written, I think people who registered a year ago or 50 years ago would be eligible to count towards the $47 for bringing in somebody and to be eligible to sign the petition and get the $1 million.
But even if some of the voters were registered already, if some of them weren't registered, and the odds are good that's the case, then he's violated the law.
Right. If he's paying people to register to vote, that's illegal.
Now, Musk is saying he's not paying them to register to vote. He's paying them to sign a petition. But he only wants people who are registered to vote to sign a petition.
I think that one's easy to get by. He is paying for the joint activity of being registered and signing a petition. You sign the petition and weren't registered to vote, you get nothing. So clearly being registered to vote is crucial to getting paid and being eligible for the $1 million.
So then could he be prosecuted?
Conceivably. I mean, it is a crime. I mean, it would obviously be very, very controversial because he's written it relatively carefully. And it's true that many of the people he's paying presumably were registered before, but if it does have the effect of getting some people to register who hadn't been registered before, then I think it does fall within the statute. So the thing is, it's a federal crime. So although Josh Shapiro has raised it as the former Attorney General of Pennsylvania, the U.S. Attorney would actually have to decide this. I guess the local U.S. attorneys in the relevant states are possibly the Attorney General. And it would be a pretty dramatic thing to do, frankly. And what he's doing is pushing the envelope, if not breaking through the envelope, but it would be a pretty dramatic response also.
What about state laws? Don't most states have laws?
Most states have laws somewhat similar to this. I don't know the specifics of Pennsylvania or Michigan or the other battleground states, but it's possible that there would be. It would make sense. I mean, federal law is interesting in that it applies to paying people to register, not just paying people to vote. And I don't know for a fact that every state has a similar rule, but it wouldn't surprise me.
Apparently, after people started talking about this, they reframed the giveaway as a job opportunity, saying winners will be selected to earn $1 million as a spokesperson for America PAC. Does that get around it?
It might. I mean, the trickier one is the bringing in the people who are registered voters. I mean, being rewarded for bringing in registered voters also. But it might. I mean, the whole thing is a gray area. I mean, he's being very careful in terms of what he's paying people for. And as long as he has some deniability that registration is the goal as opposed to something else, you might decide that you're an employer and you only want to hire registered voters because you think they're more responsible workers. It's not clear to me that would be illegal.
So it seems like the line is blurry and a little confusing. So sum it up for us here.
Okay, so I think he has walked up to the line of violating the law and might have violated the law and might have just walked along the line. The law clearly prohibits paying people to register to vote. But so long as he's able to treat this as registration, which would include pre-existing registrations, as a qualification for something, he might be able to get away with it. Certainly the people who might be able to get this reward who were registered in the past, it's hard to see what the violation is. But yes, to the extent that people are getting rewarded for registering now, that would be a violation of the law. Now, I should also point out that registration in Pennsylvania closed yesterday. So at this point, we're talking about people who registered in Pennsylvania, at least, I don't know when it closes in the other states, in a fairly narrow window of days. So I think it's basically not much more than a week where this offer was available, and it's now closed. I mean, people can continue to get the $1 million. I think they're pulling a name out of a hat or whatever. It's like a lottery until Election Day. But registration in Pennsylvania has closed. There'll be no new registrations in Pennsylvania before Election Day.
The federal law also makes it a crime for the person who's accepting payment for registration to vote.
Yes, it does.
So then if the people who get the $1 million weren't registered already,
they are potentially at risk. I mean, the penalty is $10,000 fine or 5 years in prison. It's hard to imagine anybody going to prison for this. It's not out of the question that out of their $1 million they might have to pay $10,000. It seems unlikely that the government would ever go after the voters as opposed to Musk himself.
How often does the government go after anyone under this statute? Is it rare?
I'm not aware. I mean, there have been incidents where things that seem like they're really not well-intentioned efforts to get people to vote. I think at some point, it was 1 year, was it Haagen-Dazs, some ice cream company, basically was offering ice cream to people who came in with the I voted sticker, and they were basically told they shouldn't do that.
Also, can we say that he has funneled almost $75 million into his America PAC? Without Citizens United, would any of these PACs be possible?
Yeah, if it was his own money, as opposed to money from Tesla or his corporations, individuals are free to spend as much as they want of their own money anytime since Buckley v. Vallejo. Citizens United only affected the use of corporate dollars, so I don't know if he's using his personal dollars or dollars from one of his companies. If it's one of his companies, yes, then Citizens United made it possible. But if it was his personal funds, then Citizens United had nothing to do with it.
It may not be technically wrong, but it just seems
It's
wrong.
icky. Yeah, no, it's paying people to register to vote, and it's designed to get people of a certain political perspective to register to vote. So, yeah, but it's, right now the law was written with other shenanigans in mind, and he came up with something different.
Not long until Election Day, Bloomberg has reported there were some 165 cases about election law percolating in the last 2 years. Can you tell at this point what might be an issue after the election?
It's hard to tell because we won't know until actually after it happens. I think what happened in 2020, nobody was predicting that. And certainly in 2000, nobody saw the hanging chads as an issue. So I don't think we're going to know until it actually happens.
Okay, thanks so much, Rich. That's Professor Richard Briffault of Columbia Law School. Coming up next on the Bloomberg Law Show. If it's Wednesday, a Houston-based boutique law firm is placing bets on lawsuits. And so far, picking winners has made the firm's partners some of the highest paid in the country. If it's Wednesday and it's noon, one law firm is placing bets on lawsuits in a unique vetting process that leads to up or down votes on cases that have cost American businesses billions of dollars in damages. The Sussman Godfrey firm has a knack for taking on cases that generate a lot of publicity and some stunning results. Think about that $787 million defamation settlement with Fox News, and they're the ones suing OpenAI on behalf of the New York Times. By investing its own time and money with contingent fee arrangements, the Houston-based firm takes the risk that it can pick more winners than losers, and in the process make more money than it otherwise would by billing clients by the hour. It seems to be working for the boutique firm with its back-to-back record-setting years. Successfully picking winners has made the firm's partners some of the highest paid in the country, with profits of nearly $7 million per partner last year. Joining me is Roy Strom, Bloomberg Law senior correspondent, who's written about the firm. Roy, tell us what happens at Sussman Godfrey every Wednesday at noon.
So at noon on Wednesdays at Sussman Godfrey, which is a big law firm well known for its plaintiff side litigation work, these lawyers, they filter into a conference room. They have offices in Houston. That's their biggest office. They walk in, there's partners on Zoom and other offices, and they go around and they pitch their colleagues, maybe as many as 150 lawyers, on the next big lawsuit that the firm should invest its time and its money in. Sussman Godfrey takes these cases on contingency fee, which means they really only get paid if they win, and so they're a big partnership. They need some way to decide what they should be spending their time on, how they should be spending their money. And so they go in front of this group of lawyers and they make their case. And the colleagues poke holes in it. They probe the sort of legal theory. They question the damages. They talk about the judges who might be involved, where the appeals could be heard, and probably anything else that I couldn't even think about a lawyer would question a case about.
And then it just takes an up or down vote of the partners or of the associates too?
Yeah, the partners vote and the associates vote. The associates are involved in the meeting as much as the partners are, and they're asked to weigh in. One of the partners we spoke with said that he was pushed in one of these meetings by an associate, and this associate's questioning ultimately sort of swayed the group to vote the case down. And that associate ultimately went on to become a partner. And I think the firm thinks that having these associates involved is a good way to build the culture of the place. You could imagine that these sorts of meetings could be kind of contentious, and if not contentious, at least a level of sort of dispute that I think a lot of firms might not be comfortable with. So having these associates in there and having them having viewed these cases through the lens of their partners for years really prepares them, I think, in the firm's view, to ultimately stand up one day and pitch for the cases that they think the firm should be taking on. So, yeah, it's a wide range of the firm's lawyers who are here in these meetings and debating over these cases.
And before the meeting, what's the prep before the meeting?
So the meetings are on Wednesdays, and partners send around on Mondays a sort of outline or written pitch about the case that they're going to bring up in the meeting. And lawyers at the firm will read that Monday pitch, and they will respond in writing over email, asking some questions, sort of getting some baseline understanding of what the case is about. And there'll be some back and forth over that email chain. And a lot of times that knocks cases out of the Wednesday meeting. One of the managing partners at the firm told us that there was no real way to get a sense of what the sort of acceptance rate is for the cases that the partners bring up, because many of the cases don't even make it into this Wednesday meeting. By the time partners have picked them apart after the Monday emails, the partner who raised it might say, okay, I have more to think about. I have more questions to answer before I go before the whole firm. Or they might say, you know what, on second thought, I think you guys are right. This probably isn't the case for us.
And does the lawyer who pitched it, does that lawyer take point on the case? Do they actually litigate the case, or are they just backing some other law firm?
The lawyers who pitch these cases will be working these cases, to settlement or to trial. The firm staffs its cases itself, of course, and so they're not a litigation funder who might have a discussion like this about how to allocate their money at different law firms through different cases. This is a law firm that's deciding how to spend its own time, and so the partners who are raising a particular case certainly intend to be involved in litigating that case alongside colleagues.
And tell us about some of the high-profile cases they've recently taken on.
I think probably the best-known case that Sussman Godfrey has taken on recently was the defamation claims brought by Dominion Voting Systems against Fox News over the sort of claims in the wake of the 2020 presidential election that these voting systems had somehow been corrupted or were part of a broader effort to steal the 2020 election. And, of course, those claims led to a $787 million settlement that Fox News had to pay, basically at the doorsteps of a trial after a lot of discovery had happened and people learned about the sort of inner discussions at Fox News about these claims, some of the reservations that even the Fox News people had about what they were saying on the air. And Sussman Godfrey represented Dominion in other cases as well that certainly were big time in the news and resulted in some huge settlements.
And tell us about the NFL suit.
Yeah, they also were behind this suit that accused the NFL of antitrust violations regarding their longtime Sunday ticket package, this offering where you could watch sort of any game that the NFL was airing, no matter what market you were in. And I think this lawsuit alleged that they had artificially inflated the price of that package, and that led to a big verdict against the NFL. It was almost $5 billion with a B dollar verdict. A judge overturned that verdict recently, so that's not going to go in the Sussman Godfrey win column, but it was certainly a newsy case, and the NFL commissioner, Roger Goodell, had to give testimony at trial, and at least the jury ruled in their favor, but the judge overturned it, like I said.
Roy, do you know how other firms decide whether they're going to take on cases? Do the partners usually vote?
Yeah, that's part of the thing that is unique about this firm is that they have grown to such a size. I think last year they brought in nearly $750 million in revenue, which makes them one of the 100 largest law firms in the country. And it's just rare that a firm with such a big contingent fee practice grows to that scale. And so the firms they're competing with are oftentimes these sort of, at least on that revenue figure, are these sort of corporate defense firms that have a much less risk-tolerant business model. They're billing by the hour. They're defending the types of claims that Sussman Godfrey would bring. But those firms do from time to time take up contingency fee cases, the way Sussman has made its name. And they oftentimes have a much less democratic sort of process for selecting those cases. Some of these firms will have a contingency fee committee that might take the information and then sort of make their own decision. It might just be a sort of litigation department leadership making those types of decisions, but certainly very rare to have a dialogue between 150 people over one case.
And you mentioned defense-oriented firms. Some of the questions that Sussman Godfrey lawyers ask are based on the defendants in the case. Does the lawsuit threaten the defendant's fundamental business model that might motivate a defendant to fight you to the death? So they're looking at all aspects of the case.
Yeah, that was one of the sort of topics that I thought was really interesting. They think about the posture, the defendant's sort of mentality going into a case, what might prevent them from settling a case like this. If you are threatening this sort of fundamental business model that this business, the defendant, uses, what does that mean for the likely outcome of the case? Does that mean that they're going to really go to the mat? Does that raise the cost of fighting this dispute? And just some of that sort of psychological discussion that they laid out, I thought was really interesting.
Successfully picking winning cases has made lawyers at the firm of Sussman Godfrey among the highest paid in the country. Last year, it brought in nearly $750 million in revenue, the result of major contingency wins, including the $787 million Fox settlement with Dominion Voting Systems. The firm's unique process of vetting cases plays a central role in its skyrocketing revenue. I've been talking to Bloomberg Law senior correspondent Roy Strom. Roy, these Wednesday meetings are nothing new. They date back to the firm's founding some 45 years ago?
That's right. The firm got its start in Houston. Founder Steve Sussman was a very big personality, a very well-known, successful lawyer who sort of crafted this business practice and who was well-known for the types of cases that Sussman still does now. Steve Sussman died in 2020 unexpectedly after a bicycle accident, but the firm is really molded and shaped by the way he ran things.
How do they determine partner compensation?
The partner compensation there is sort of interesting because it's, of course, a partnership, and so the profits of the firm are divided up every year to the partners, but the partners sort of have their own risk tolerance, and they kind of manage their own books of business, for lack of a better term. They sort of choose which cases they're going to be working on, and some of the partners are very risk tolerant. They might have sort of all of their cases all their time being spent on contingency fee cases. And as the managing partners of the firm explained to us, that will impact their personal compensation. They might have some leaner years while they're waiting for those cases to finalize, and then they'll, of course, be compensated in line with the conclusions of those cases. Their firm does do hourly billing cases. It's a smaller portion of their revenue compared to most any other firm. But partners who work on those will be compensated more like your typical big law attorney. So the partners are sort of almost operating, they're making decisions based on their own risk tolerance in terms of what their compensation will look like year to year. But the basic aspects of that compensation model are the revenue the partner generates and the work that partner does for other cases that they didn't bring in. So that's fairly consistent with other firms. It's just the partners kind of pick and choose how much of their work is done on this contingency fee basis, which just by its very nature has a much lumpier return model compared to the billable hour.
In a lawsuit last year, an agreement between a litigation funder and the law firm became public, showing the funder agreed to pay the firm's monthly fees of up to $6,915,000. But usually the firm is the one funding the litigation?
Yeah, of course, litigation funding has grown. It's become a much more prominent piece of contingency fee litigation. And there was this episode last year, a lawsuit, where the agreement between Sussman Godfrey and a litigation funder became public in the course of the litigation, and it did show that Sussman was receiving sort of monthly fees on the case. And from what I have heard and from what they said, that was more of an outlier for the firm. They often prefer to use litigation funders to pay for the cost, some of the expenses and costs of cases, but they're less likely to use it in a way that would impact the actual return or the damages, such that the funder is getting a large portion of the total award from a case.
What I thought was interesting also was the hiring practices, that they only hire people who have clerked for federal judges and they don't hire lateral partners? Yeah.
So the firm from the beginning was really looking for a sort of, the top of the top talent coming out of law schools. Of course, they are litigators, and so they do hire people. It's a requisite to have a federal clerkship before coming to the firm, which kind of sets the bar pretty high to begin with. Mm-hmm. And then they really hope, unlike a lot of big law firms, which kind of accept and acknowledge that associates might work there some amount of time and then go find something else to do, I think this firm really does want these associates to stay there for the long haul, to understand their business, to grow into it and become partners. And they are much more focused on promoting partners from their internal ranks as opposed to hiring from other law firms, which of course does set them apart from your typical big law firm, which today very, very active in, poaching partners from rivals. It's just something that this firm hasn't done much of, doesn't intend to do.
So if it's Wednesday, we know where all the lawyers at Sussman Godfrey are. Thanks so much for coming on the show, Roy. It's a really fascinating story. That's Bloomberg Law senior correspondent Roy Strom. In other legal news today, at a legislative committee hearing today in Texas, a death row inmate who's proclaimed his innocence for more than 2 decades had some high-profile supporters speaking on his behalf. Criminal defense attorney turned author John Grisham says the system rushed to Judge Robert Robertson, an autistic man who was convicted of shaking his 2-year-old daughter to death in 2002.
The science was terrible. The jury selection was awful. From the opening bell, the prosecutor was allowed to point a finger at Robert and call him a baby killer or whatever. That persisted throughout the trial.
Shaken baby syndrome has been discredited as the basis for criminal prosecutions. And psychologist Phil McGraw, better known as Dr. Phil, told the committee that his review of Robert Robertson's case has convinced him that the 57-year-old did not shake his young daughter to death.
If we start executing people in Texas absent due process, absent fair trial, we are going down a really dangerous road.
Robertson's absence at the highly anticipated hearing was another twist in last-ditch efforts to spare his life. He had been set last Thursday to become the first person in the country executed over a murder conviction connected to a diagnosis of shaken baby syndrome. He was actually taken to the death chamber and was waiting in a holding cell when the Texas Supreme Court abruptly halted plans to give him a lethal injection. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.